I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your boy TP. Today we are courtroom hopping into the courtroom of Judge Kalo Wilcox out of the state of Michigan. And from what I understand, Judge Wilcox has a sovereign citizen before her with a lot to say. But before we jump into this proceeding, let me shout out Sovereign Citizen Encounters for providing me with this video. With that being said, guys, I'm interested in seeing how this interaction goes. So without further ado, let's jump into this proceeding.
I'm Ty Warren. Mr. Warren is here. He currently does not have an attorney appointed.
Mr. Warren. Mr. Warren, you want to come on up and, all right. You want to have a seat up here? Or would you rather stay where you are?
I'll stay here. Then.
Okay, that's fine. We can still hear you and communicate well. So we're taking up the case 24 on 130. And Mr. Warren, you've filed this motion to dismiss the state's charge. And I've had a chance we were together, I don't know, a few weeks ago, and we set this hearing. And so I'm going to turn to the state here. I don't have anything filed.
That's correct, Your Honor. And when I was reviewing this late last week, it came to my attention that nowhere in the record did the court authorize the defendant to proceed pro se. And the issue the state has is we haven't provided discovery to the defendant. We haven't provided discovery to counsel for the defendant. And until he's authorized by the court to go pro se, we can't really respond to his motion either.
Well, I think we're at a motion, and this was filed in February, and since April of 2024, it's been clear, Mr. Warren, who's also to us known as Mr. Azeltine, but Mr. Warren is proceeding representing himself, and he's made it very clear in his pleadings, and I'll allow that, and it's been allowed throughout. So are you going to respond to this motion today?
I can respond orally to the motion, Your Honor. Yes.
Okay.
I do have to express some hesitation and concern here, Your Honor. The state currently has a case coming back from a Superior Court appeal where the court did not go through the pro se properly with the defendant, and therefore the court is overturning that case.
Well, this goes back to filing of April 2024. I haven't looked through all of the recordings, but I think Mr. Warren, I think it's been clear that you're wanting to represent yourself since this beginning. Is that right?
Yeah, let me make that clear. Without recourse, as my unrebutted affidavit on file in this case stipulate, I am not the ens leeches, Mr. Azeltine. I'm not Mr. Warren. I'm a man. My mother called me Ty Warren, and I'm of the Azeltine family. Sovereign has spoken of in Yickwold versus Hopkins, and not the corporate artificial entity Ty Warren Azeltine in all capital letters, nor representing the defendant, Ty Warren Azeltine. I'm not here pro se. I'm here by special visitation, sui juris, in propria persona. You may call me Ty Warren. I'm here under duress and threat of arrest by special visitation, reserving all rights without prejudice under UCC 1-308, and refusing any contract not explicitly agreed to. For the record, I do not consent to the court's general jurisdiction over my person.
All right. So you're in a criminal court, and you have the right to be represented by an attorney or to represent yourself, to speak for yourself, put it that way. And not have an attorney represent you. So where are you?
I'm here to present myself as a man, not as a corporate entity.
All right. And I think throughout, we've talked about this whole idea about appointing counsel or not, and we haven't done that because you didn't want that. And I remember the times that we've been together. I can't speak for any other judges without looking at their records or listening to their records. So And the prosecutor's office has been here throughout the times that you've been before the court. And the last hearing, April 8th, was when we cleared up that warrant and we set this hearing. So it's abundantly clear, and that Ty Warren here is speaking for himself or representing himself, and we're going to go forward on that because we've had those discussions for over a year now.
Again, I'm not representing myself or the defendant.
Right, I understand. So I see in the pleadings that you filed that there's at least one. First thing that might be most dispositive is the motion to dismiss based on Court Rule 3.6, which is a suppression of evidence, saying that there was no basis in the law for you to be stopped by the officer. So we're going to start there. Well, I'll make the record here as to jurisdiction and venue. I think I've made that record already, and I don't see anything. I'll hear from the state if there's anything else. And we talked about this at the last hearing, that this is the district court. This is an allegation of a driving offense under RCW 61, also an allegation of obstructing law enforcement. Those are properly filed in this court as they're alleged to have occurred here in Thurston County. And this court has jurisdiction, subject matter, and in personam jurisdiction. So venue is proper as well. So
I'm here to challenge that.
I understand, and that's part of your motions. Just making the record that there isn't any basis in your motions that have undercut that reality. So the court does have jurisdiction and venue is proper. So we're gonna hit that 3.6 motion. And I'm going to hear from the state as to what evidence they have to present. And I'm looking back to that motion. I think it's about 33 pages that was filed back in February and reiterated throughout. So Mr. Thompson.
You're speaking of my affidavit?
Yes. And you've filed a lot of information. I've taken it all together. It starts out with that motion to dismiss from going back to, June of 2024. I misspoke.
You can sum it all up with my most recent affidavit.
Yeah, and that I'm also including in my reading, everything you filed. So now I'm going to jump to the state because they're the ones who have to defend against your motion. I will hear more from you. So, Mr. Thompson.
Thank you, Your Honor. And the sworn statement that our office provided at the initial hearing stands that the defendant was stopped for speeding, and during the course, that was the basis of the stop was speeding.
And so resting on that initial probable cause finding in April.
That was, yes, correct. That was the basis for the initial stop, which would give rise to the Terry stop for an infraction. And from that point on, the defendant refused to give name and gave a world passport ID card or world passport. I don't even know how to fully describe it accurately other than not a document from a government entity.
So anything you'd like to say more, Mr. Warren or Ty Warren?
Yeah, plenty to say.
As to that issue, let's kind of focus in on issue by issue.
What the prosecutor has just said, he stated that I did not give a name, and then he counteracted himself by saying I did give a world passport ID, and then he said it was not a valid or whatever he said, and not valid or not recognized by the state, but whatever the case, I would like to present what I have to say here. I'm a man visiting here, especially not generally sui juris and the trial solely to challenge jurisdiction
Let me ask you a quick question. Did you already file the information that you're reading?
No.
No, this is new?
Yes.
Okay. All right. You have an extra copy?
This is just my oral.
Okay. All right.
Printed out.
Let's see. Try and focus in on the motion to dismiss that you have for suppression of the evidence.
This is what this is all about. It's all about jurisdiction.
Well, we're not talking jurisdiction.
Has been proven on the record, and I have seen no proof of jurisdiction.
Talk to me about your motion to suppress. Talk to me about your allegation
I'm
here.
here to establish jurisdiction or not.
Well, I've
And-
already
and
maybe I should be more
There
clear.
are no facts on the record.
I
about
deny your
jurisdiction.
motion as to jurisdiction in this court. So this court has jurisdiction and
You haven't even
venue.
heard
What I
have
need
say
to hear
about it.
from you is what do you have to say about your motion to dismiss for
I
a
can't say
bad stop?
anything about a motion to dismiss
Okay.
until jurisdiction has been established.
I've denied your motion. This is the correct court. We have jurisdiction, so move on. You can disagree with the court's order, but you can't make it better by just continuing to argue about it. So let's move on to that other motion that potentially is dispositive, the stop.
One moment, please.
Sure.
I respectfully object to that ruling and give notice. I contest the court's assertion of jurisdiction all the way. Let the record show that I timely and persistently challenge jurisdiction, and that challenge remains unanswered by factual evidence.
Anything else? Just looking back through your affidavit and your motion. Anything else for me to consider from
Yes,
you?
Like I said, I have plenty to consider.
Okay. About, first off, as to this motion to dismiss based on the bad stop, is what you say.
Yeah. Excuse me?
Your motion to dismiss based on a lack of good reason for the stop. That's what I'm first dealing with.
I can't even address that issue
Okay.
without jurisdiction being established.
Okay. All right. Well, all right, Mr. Ty Warren, Mr. Azeltine, however you want to be referred to. So this is the deal. I'm granting your motion to suppress all evidence after a stop. I have no evidence presented that I can consider. This was filed by you in April of 2024. And there's been affidavits and information filed thereafter, all in the court file. We've set this for trial, or we've set this for motion as recently as April 8th. State was present. It's kind of like, for whatever reason, the state decided not to join or prosecute. So under Rule 3.6, I don't have any evidence to overcome what your assertion is that you were peacefully driving down the street. And simply the probable cause statement from the beginning to allow the set of release conditions is not sufficient. There isn't anything other in the court file, in the court record, that would allow the state to overcome your motion to dismiss or to motion to suppress evidence. So all evidence obtained, stopped forward, is suppressed or not allowed to be brought forward in trial by the state against you. So with that ruling, Mr. Thompson, from the state's point of view.
I believe the court is, well, I have nothing to add, Your Honor. The state will be filing an appeal.
All right, so are you saying that with that order of suppression, state, you're thinking an interlocutory appeal and able to go forward?
Yes, Your Honor.
Okay.
Well, I suspect the court intends to dismiss the case at this point. So I don't think an interlocutory appeal is what will happen, but an appeal nonetheless. You know, again, the state stands by its position that I put into the record regarding his appearance today pro se. I still do not believe that the court has gone through it properly. I will note one additional thing for the record, that in his motion to dismiss, he specifically says that he's doing so under duress, which calls into question the validity of any of his filings. And the reason why the state still believes, even over his objection, counsel should be appointed, because he is not here of his own free volition, as he said more than one occasion in more than one filing.
It's clear to the court he is throughout all of this. The semantics that he likes to use are not persuasive to the court. So, but as I said, the prosecution's decided, not to present. So, as we know, Mr. Azeltine, as we know you as, this matter is dismissed, given that suppression of all the evidence, and you're free to be on your way.
Thank you.
Thank you, sir.
Well, guys, we've come to the end of this proceeding. And honestly, I don't have a whole lot of commentary on this one. I mean, we do see Mr. Ty Warren talking about he's not representing himself or the defendant, goes into a lot of sovereign citizen lingo back and forth about jurisdiction. But unbeknownst to him, he didn't even have to do all of that because the evidence ended up being suppressed because of, the lack of due diligence on the behalf or on the part of those that was supposed to make everything happen. In Mr. Warren's case, we see the prosecutor definitely wasn't happy about that, definitely felt like some of the things that Mr. Warren said, during his proceeding and, all of his times coming to court should have been taken into consideration for it not to have been dismissed. But we see Judge Wilcox, the evidence was suppressed. She ended up dismissing it. Prosecutor says, listen, I am going to appeal it. And who knows, he might be back in court soon. But my thought is does Mr. Ty Warren feel like this is a victory on the sovereign citizen behalf, on the lingo behalf, which we know that it wasn't, but I wonder if that's what he's going to tell himself to just continue to keep going forward and spewing the lingo that he's been spewing. But I know I said I wasn't going to say much commentary because it wasn't a whole lot to be said, but I did want to say that. But with that being said, guys, as always, thank you for all of your support in every way that you do support. I just want to say, keep liking, subscribing, sharing. Channel's growing. The commentary has been great in the comments, so thank you for that. And with that being said, guys, this is Sovereign Citizens Hall of Fame. And for now, Sovereign Citizens Court is adjourned. I appreciate you guys. Talk to you soon. God bless.